Who used your green access card at 11:43 p.m., Mr. Pierce? That was the question that ended Nolan Pierce's release. Not the guilty verdict from the month before, not the sentencing memo that already put him in serious trouble, not even the photographs of storm debris, lots that federal agents said had been staged to justify fake invoices. It was that one question asked in a quiet voice from the bench while a worn green access card sat inside a plastic evidence sleeve on the prosecutor's table. By the end of the afternoon, Pierce was no longer a contractor awaiting sentencing from the comfort of his waterfront house. He was in custody. And the worst part for the defense was that the government did not get there with one dramatic witness or one emotional outburst. They got there with a badge, a loading dock camera, a gray backup drive that disappeared after a preservation order, and a timeline that kept tightening every time Pierce tried to explain it away. I've spent decades around federal courtrooms, and the most dangerous hearings are rarely the loud ones at the start. They look procedural, controlled, professional. Then one object appears, one answer slips, and suddenly the hearing is no longer about schedule or conditions. It is about whether the person at counsel table can still be trusted outside a detention unit. Pierce had built his public image carefully. 44 years old, founder of Gulf Meridian Recovery, a storm cleanup contractor that won emergency debris removal deals after 2 major hurricanes. In public, he was the polished executive in rolled-up sleeves, talking about resilience, rebuilding, and getting communities back on their feet. In court, the government said he was something else entirely, the architect of a billing scheme that charged counties for truckloads of debris that never moved, inflated landfill weights, and sham subcontractor payments routed through relatives and shell vendors. A jury had already convicted him on wire fraud, conspiracy, and false records counts. The only thing left was sentencing. Pierce came into the hearing expecting to stay on bond and ask for expanded home confinement. His lawyers framed him as a nonviolent first offender, a father, a taxpayer, a man with deep community ties who had shown up for every court date. That should have been routine. It was not. The courtroom still looked calm when the prosecutor stood. No raised voice, no theatrics, just a request for the court to address an emergency motion before discussing sentencing dates. The judge looked down, saw the filing, and her expression changed in a way defense lawyers notice immediately. Not anger, something worse. Interest. Pierce's attorney rose halfway and asked for a brief recess to review the attachment. The judge denied it. Then the prosecutor picked up the evidence sleeve. Inside was the green access card. It was the kind of object most people would ignore in ordinary life. Rectangular. Scuffed. A white sticker label partly peeled away at one corner. But federal hearings turn on objects like that all the time because objects do not panic. Objects do not improvise. Objects sit there and force human beings to explain them. The prosecutor told the court the card had been issued to Pierce personally for an off-site records facility leased by Gulf Meridian on the east side of the city. According to the government, that building stored dispatch logs, landfill manifests, backup accounting images, and archived route data from the company's busiest hurricane contracts. 3 weeks after the guilty verdict, and 6 days after the court entered a preservation order covering all company records, that card was used to enter the facility late at night. That alone was damaging. The next part was worse. The prosecutor moved to admit a short chain of exhibits. First, the access logs from Iron Harbor record storage. Second, still images from a loading dock camera. Third, cell site mapping for 2 devices assigned to Pierce. Fourth, grand jury testimony from Gulf Meridian's former compliance director, who had already pleaded guilty and agreed to cooperate. Defense counsel objected to the hearing turning into a mini-trial. The judge overruled it almost immediately. She said the issue before the court was not whether Pierce would be retried. The issue was whether he had violated the court's trust after conviction and while under a direct preservation order. From that point on, every paragraph of the hearing got tighter. Exhibit 1 was simple. The facility log showed a single successful swipe at 11:43 p.m. on a Saturday. Cardholder, Nolan Pierce. Entry point, east archive door. No paired exit swipe. A second scan at 12:08 a.m. opened the interior records corridor. Defense counsel said access cards get shared in businesses all the time. Someone else could have used it. Pierce himself sat very still, jaw set, hands clasped so tightly his thumbs had stopped moving. Exhibit 2 gave that explanation less room to breathe. The dock camera footage was not cinematic. Grainy, fixed angle, sodium yellow light over a concrete loading area. but it showed a dark pickup reversing toward the rear bay at 11:51 p.m. It showed two men carrying out 3 banker's boxes and 1 compact gray case about the size of a hard drive archive unit. One of the men wore a company fleece. The other wore a cap pulled low. You could not make out faces cleanly. You did not need to. What mattered was movement, entry, removal, timing. The prosecutor enlarged one still image and placed it on the screen. On the back window of the pickup was a Gulf Meridian parking decal issued to executive vehicles only. Up to that point, Pierce still looked composed. Then he leaned toward his lawyer for the first time and spoke long enough that the lawyer stopped writing and just listened. Exhibit 3 was where the hearing stopped being about coincidence. The government's agent testified that a phone assigned to Pierce hit towers consistent with the Iron Harbor facility area beginning at 11:37 p.m. and remained active there until after midnight. A second device, a tablet registered to his home office, pinged near the same corridor 21 minutes later. The prosecution did not have to prove he personally carried both. They only had to show that the late-night entry was not some random rogue employee making an unsanctioned stop with no connection to the man on bond. Defense counsel tried a different route. He argued that Pierce had been preparing to transition company records to a restructuring consultant. He said staff had authority to handle storage. He said there was no proof anything had been destroyed. Then the prosecutor asked permission to approach with the cooperator text chain. That was the turn. The judge allowed it. Printed in large format were messages between Pierce and his former compliance director, Elena Mora, sent less than 2 hours before the badge swipe. The first one from Pierce read, "Use the old badge, not mine." The second, "Pull landfill binders from 4B and the gray image case." The third, sent after midnight, read, "Do not leave root copies there if they still show county variants." Defense counsel objected on foundation grounds. The prosecutor answered that Mora had authenticated the messages under oath and that phone extraction reports matched them. The judge read them twice. Pierce's posture changed after that. He no longer looked like an executive participating in a hearing. He looked like a man calculating whether every previous answer he had given the court was now turning against him. This is where people who do not spend time in federal court sometimes miss the real danger. A convicted defendant, on release, is already standing on thinner ice than he was before trial. Add evidence that he touched records after a preservation order, and you are no longer arguing abstract character. You are arguing present tense obstruction. Judges take that personally because the conduct is not just against the government. It is against the court's command. The prosecutor did not overtalk it. Good prosecutors usually do not when the exhibits are carrying the load. She moved to the gray case. Agents had executed a search warrant on a secondary warehouse used by Gulf Meridian's fleet manager 3 days before the hearing. They found the gray case on a metal shelf behind boxed safety vests and pallet wrap. Inside was an imaging unit containing mirrored accounting backups from the hurricane contracts at issue. According to the forensic examiner, the backup history showed selective deletions made after the preservation order but before the warrant. The deleted segments were not random. They were date bands tied to landfill variance reports, internal truck route corrections, and vendor payment reconciliation. One object, one implication. Next, reveal. The prosecutor then displayed a summary chart. Not to prove the entire fraud again, just enough to show why these particular records mattered. On county invoices, Gulf Meridian had billed for thousands of debris haul miles at emergency rates. Internal route corrections, where they still existed, suggested many of those hauls were duplicate loops, partial runs, or trucks that never reached the listed landfill. The missing date bands overlapped the exact billing periods the jury had focused on during trial. That was only the first problem. The next problem was witness pressure. Mora, the former compliance director, had not just turned over texts. She had also testified that Pierce called her 2 days after the verdict and told her, "Everybody survives this if the record said gets cleaner." Those were her words. Defense counsel attacked her credibility instantly. Cooperating witnesses do that to themselves just by showing up. Every jury instruction on earth tells you to treat them carefully. But the government had something to steady her. A voicemail, not a perfect confession. They almost never are. Just Pierce's voice, measured and low, saying, "We do not need old route images confusing sentencing. Handle storage and stop answering questions like you still work for them." The pronouns were slippery. The intent was not. The judge asked to hear it again. Pierce closed his eyes when the playback started the second time. Then came the question he could not answer cleanly. The judge set the evidence sleeve on the bench rail and asked, Who used your green access card at 11:43 p.m., Mr. Pierce? His lawyer asked to respond for him. The judge said no. She wanted a direct answer. Pierce cleared his throat and said he did not know. He said cards moved around the office. He said old credentials were sometimes left in desk drawers. He said he had not personally entered the storage facility that night. The judge asked why a phone assigned to him was there. He said he may have left devices in company vehicles. The judge asked why his text said, "Use the old badge, not mine." He said the wording was being taken out of context. The judge asked what the context was. That was the silence that ended him. Not a movie silence. Not 10 dramatic seconds. Just long enough for everyone in the room to understand there was no clean version coming. Defense counsel stepped in and tried to land the plane. He argued that even if the court viewed the conduct suspiciously, detention was extreme. He offered stricter monitoring, seizure of all devices, third-party custodians, full access to company servers, whatever the court wanted. But hearings like this are usually over before the ruling begins. Once a judge concludes the defendant used release as an opportunity to tamper with records, every proposed condition starts sounding like a system that already failed once. The ruling was short. The judge found by clear and convincing evidence that Pierce had violated conditions of release, had participated in conduct aimed at altering or removing records subject to court order, and no longer presented as a defendant the court could trust under any combination of conditions. She revoked bond. She ordered him remanded immediately pending sentencing. She referred the record to prosecutors for review of additional obstruction charges. No flourish, no speech. Then the chair scraped. That sound always lands harder than people expect. Pierce turned toward his wife in the second row as if he still had time to say something meaningful. He did not, but Deputy Marshal was already at his shoulder. Another step to the aisle. His lawyer put a hand on his arm and said something too low to catch. Pierce nodded once, but the expression on his face had changed completely now. The polished public man was gone. In his place was someone trying to hold together the last fragments of a plan that had just failed in public. When the cuffs closed, his daughter stood halfway up before her mother pulled her back down. That metallic click is one of the most honest sounds in a courthouse. It tells you argument is over. Status has ended. The room belongs to procedure now. Pierce did not resist. He did something I have seen more than once from white-collar defendants who believed they would never actually hear steel close around their wrists. He looked down at the cuffs as if they were administrative errors that might correct themselves if he stared long enough. They do not, and the legal damage was not finished. Immediate detention meant Pierce lost the practical advantages of preparing for sentencing from home. No more curated family photographs on counsel tables. No more leisurely review sessions in a private office. No more ability to manage the company's remaining records through intermediaries who still answered his calls. Every jail phone call would be monitored. Every visitor screened. Every movement reduced to institutional schedule. The obstruction exposure widened everything else. Under the federal guidelines, post-verdict record tampering can affect acceptance arguments, obstruction enhancements, and the judge's overall view of character at sentencing. It also gives the government leverage over anyone who helped move the boxes, touched the image case, swapped devices, or repeated instructions after the preservation order. The two men on the loading dock were suddenly no longer background figures. They were potential witnesses or targets, and that gray image case created a second line of danger. Forensic recovery was still underway. Deleted does not mean gone, especially when agents get mirrored backups fast enough. If examiners reconstructed missing root bands or payment edits, prosecutors would have a cleaner picture of which county invoices were false, which managers knew it, and whether Pierce's trial testimony crossed from aggressive defense into perjury exposure. Then there was the money. Sentencing in fraud cases does not turn only on the broad story. It turns on numbers, role, obstruction, and whether the judge thinks the defendant still believes the rules are negotiable. Pierce had already lost on the merits. Now he was losing on posture. That can add years. The defense came in hoping to talk about home confinement, medical care, family hardship, and the nonviolent nature of the offense. They left with a detention order, a possible obstruction referral, and a record that made Pierce look less like a man awaiting punishment and more like a man still trying to manage evidence after conviction. That distinction matters. A lot of defendants think the trial is the war and sentencing is cleanup. In federal court, Sentencing is often where judges decide whether the person before them learned anything at all from losing. If the answer appears to be no, the courtroom gets colder very quickly. And here, one green access card may end up doing damage far beyond the hearing where it first appeared. Because if that card ties Pierce to the late-night retrieval and the gray case yields reconstructed deletions, the government will not just argue he committed fraud, they will argue that after 12 jurors convicted him, he still believed he could edit reality one more time. That is the kind of fact pattern judges remember. So let me ask you this. Once the badge swipe, the texts, the voicemail, and the missing backup all pointed in the same direction, was immediate custody the only reasonable outcome? If you want, I can make another one with a completely different evidence object and case type.